This conference will now be recorded.
I'm an attorney here at Herzl Law, and one of the areas that I focus in is the Fair Housing Act. And so today we're going to talk through some common issues that come up with the Fair Housing Act, and specifically the different areas of discrimination that apply. And this past year, we've actually had a few important updates that have happened in the fair housing world. And so this will, hopefully get you up to date on some of those changes that may be coming your way and to keep note of. So I can get my computer to cooperate and take me to the next slide. There we go. So this is just an overall roadmap to kind of show you where this presentation is going to be going. So I'm going to just give you a brief overview of the Fair Housing Act, and then we'll take a deep dive into each of the areas of discrimination that the Fair Housing Act covers, and provide some examples under each. So we'll be taking a look at disability discrimination, familial discrimination, race, religious, and sex discrimination. And so basically by the end of this session, the idea is just so you can walk away with a better understanding of what the Fair Housing Act is, what it covers, how it may impact your association, and just really to make you more aware of when these potential issues come up in your association that, you might get a little red flag that says, oh, like this might be a fair housing problem, and so we might want to investigate this a little bit further before we move forward. And so as I mentioned earlier, there have been updates this year and some important updates in the fair housing world, specifically regarding emotional support animals. There was guidance that came out of HUD, familial discrimination claims. There was a case out of the District of Idaho, which seems far away, but it is helpful guidance for us here in Michigan, and sex discrimination claims based on a recent United States Supreme Court case, which we're familiar with, probably not in the area of housing. So to start off, the Fair Housing Act prohibits discrimination based on the categories that we mentioned before. And something important to keep in mind is that the Fair Housing Act applies to most all housing issues. I think some people think that the Fair Housing Act only applies to public housing or government subsidized housing, but it actually applies to any sort of situation involving the renting or buying of a home or engaging in other housing related activities. And it does actually cover many instances of private housing. And so that's just one thing to put, on notice, is this really does apply to most housing. And so that includes many of our community associations, whether they're condominiums or their homeowners association. And something also important too is, everyone is pretty familiar with direct discrimination. You can very clearly see it, but this is also targeted at discrimination by impact. So even though the words themselves look pretty neutral, they don't look like, they're discriminatory. If their impact is discriminatory, that can be a potential issue as well. And so the Department of Housing and Urban Development is primarily responsible for administering the Fair Housing Act. However, the Michigan Department of Civil Rights here is also in charge of enforcing the Michigan Elliott Larson Civil Rights Act, which has pretty similar provisions to the Fair Housing Act, the Michigan Persons with Disabilities Civil Rights Act, and also the Fair Housing Act. And they also have an agreement with HUD to accept HUD housing complaints. So it is possible, a homeowner could submit a HUD complaint, or could submit a complaint to HUD, and then HUD would then kick that back to the Michigan Department of Civil Rights. And so there's kind of two different, there's a federal and a state level here that you might encounter if one of your homeowners faces an FHA violation. And there's some different tracks that a complaint can proceed for the Fair Housing Act violations. So it can go administratively, so that would be a complaint to HUD or a complaint to the Michigan Department of Civil Rights. And that could also then potentially result in a lawsuit brought by the government, or it could just be a civil lawsuit that's brought directly by the homeowner against this association. So we'll talk a little bit about what the different processes might look like. So if a homeowner goes directly to the Michigan Department of Civil Rights with a complaint, generally they have about 180 days to file from the violation or when they should have known or discovered the violation. And then the department will undergo an investigation. So they'll investigate the allegations, they'll contact the association, gather more information, and during that time, similar to how many cases work in the trial courts, we'll try to get some sort of conciliation agreement between the association and the complaining homeowner. If some sort of conciliation agreement can't be reached at the end of the investigation, it's either going to result in a no charge, or the department's going to find that there's sufficient grounds, a charge will be issued, and then the association will answer and they'll have a hearing in front of the commission. So this is all done outside of the court process and is completely administrative. And then based on the commission's or the department's finding, a cease and desist order might be issued, or they may find the charge needs to be dismissed. HUD operates in a very similar manner. And so you'll have 1 year to file from the date of the last date of the violation, a similar process of an investigation, a voluntary compliance agreement will try to be reached in the interim. And the results, if an agreement can't be reached, they might find, there's no reasonable cause and there's no charge, or they might issue a charge. And then from there, the case would go in front of a federal district court. So here in Michigan, that would be either the Eastern District of Michigan or the Western District of Michigan. And that case could either be brought by the government. So the Department of Justice might say, hey, we think that this is a case that we want to take on. We want to lead the way on this. Or the homeowner could hire their own attorney and have their own attorney bring that case. It can also stay within the administrative process as well and just be heard in front of an administrative judge. And then even if no charge results from this HUD complaint, a homeowner could still decide to bring a private civil lawsuit. So that would be the homeowner directly filing a lawsuit against the association. And then just to provide a quick overview of potential liabilities. So if it stays in the administrative process, the potential liabilities are actual damages that the homeowner has suffered, injunctive relief to make the association stop from doing something, or equitable relief to make housing available depending on what the circumstances are, reasonable attorney fees and costs, and potentially a civil penalty. A federal court order, if it goes in front of a federal court, it's going to be the same potential liability, but with the additional potential impact of punitive damages. So actual damages are going to be limited to what actual damages the homeowner incurred, whereas punitive damages are meant to punish the association and provide, basically provide an incentive not to commit the conduct again. All right, so before we move on to disability discrimination, I don't know if anyone has a question on the overall impact. We have a smallish group, and so if you do have a question at this point, I'll just wait a few seconds and we'll see if anyone has a question on the overall scheme of this, and if not, we'll start diving into the different areas of discrimination. All right, hearing no one jump in, I'm just going to go ahead and now talk about disability discrimination. So again, we're going to be talking about 5 different types. So disability discrimination is one that associations may see pretty frequently because they involve reasonable accommodations and modifications, emotional support animals, things of that sort. So if this is an area of the Fair Housing Act you're likely to encounter, this is one of those. And it's important to note from the beginning that this is disability discrimination under the Fair Housing Act. This is not disability discrimination under the ADA. And so just important to keep those distinctions in mind. And so our conversation tonight will be limited to the Fair Housing Act. And so the Fair Housing Act defines disability. I have it up here on the screen. So basically any physical or mental impairment that substantially limits one or more major life activities. And some examples that HUD provides, I have here below, but this is not an exhaustive list. And so it's important to recognize that disability under the Fair Housing Act can be pretty broad and encompassing. And so it's really important if you get a disability, some sort of reasonable accommodation or modification request, that you look at the Fair Housing Act's definition of disability, because, you know, it can include things even such as, you know, drug addiction, alcoholism, some things that generally we may not think right off the top of our heads would qualify. And so we're gonna start with our first scenario of how this plays out actually in our community associations. So first up, we have here Bob, who's in a wheelchair. He needs a wheelchair ramp. The bylaws do not permit modifications to the common elements without the board's approval. He submits his plans for his ramp to the board, and the board does not take any action, doesn't provide him any response for 3 months. So Bob just goes ahead, builds the ramp without approval, and then finally the board says, hey, would you mind making that ramp a little bit smaller as a reasonable accommodation to us? And Bob refuses to remove the ramp and threatens to sue. And so the question we have here is, who's going to win? If Bob sues, who's going to win this potential case? And so if you want to be brave and say what you think the answer would be and why, you can unmute yourself and let us know your thoughts. Okay, I'm going to assume no one's going to step up to the challenge here. So this is a condominium, as the facts note, and Section 47A of the Michigan Condominium Act talks about these reasonable accommodation and modification requests based on a co-owner's disability, and says that if the board does not approve a request within 60 days, it's automatically approved. So here, the board took 3 months to decide, or they didn't even decide. They had it for 3 months before Bob built his ramp without approval. And so under the Michigan Condominium Act, because they didn't provide a response within those 60 days, his ramp, his plans for his ramp were automatically approved. And so Bob's ramp will get to stay. So for our homeowners associations, there's no homeowners association statute similar to the Michigan Condominium Act. And so Section 47A would not apply. However, the Fair Housing Act says the request is deemed denied if an unreasonable time passes. And so here we have a flip situation of, under the Fair Housing Act, if an unreasonable amount of time passes and Bob's request is denied and he had a proper request, the association may still face some potential liability issues. And so there are 3 important levels here to consider when you receive a reasonable accommodation and modification request. that are laid out by the Fair Housing Act. And they're basically 3 levels of information that the association might be able to request from a homeowner who's asking for an accommodation or modification. So first, if the person's disability is obvious or known and the need for their requested accommodation is also obvious or known, you can't request any further documentation about their disability or their need for the accommodation. So here, Bob's in a wheelchair, and I think we can assume that you know, he would need a wheelchair ramp. So the association couldn't inquire further into his disability or his need for the wheelchair ramp, but they may still want to request additional information regarding, you know, the plans for his ramp. And, you know, they want it to be maybe smaller. And so in that process of engaging with him, maybe that's something that they could have talked about and addressed. But regarding his actual disability and his need for it, they would not have been able to inquire further. The second level of information is if you know that they have a disability, but the need for the accommodation is not readily apparent, if you can't make that connection, you can ask that homeowner to provide you more information just necessary to evaluate, okay, we recognize this disability, but we just don't see how this accommodation fits here. Just provide us more information to show this. So that's something that you can inquire into. If you know one aspect of it, but you can't make the connection regarding the accommodation. And then, of course, the third level is if the disability is not obvious or known and the connection for the accommodation is not clear, then you can inquire into both. And so you can request, you know, disability-related information just to make sure that they meet the Act's definition. Typically, that might just be evidence that they've received supplemental security income, a letter from a doctor who knows them, knows about their disability, and can provide verification of that. And so in terms of medical records, that most of the time is not going to be necessary, but just some sort of verification from someone like a doctor or other professional provider regarding verifying, hey, this person has a disability and this is the accommodation that they need and this is how it lines up with that disability. So that's the important aspect of reasonable accommodations and modifications. Really making sure that once you receive a request from a homeowner, whether you're a condominium or a subdivision, that you timely respond to these requests because you want to make sure that an unreasonable time doesn't pass and therefore it's deemed denied, and that a homeowner actually really needs the accommodation, or under the Condominium Act that the request is not automatically approved if you sit on it for too long, and making sure that you're only inquiring into just the right amount of information that you need to verify that they do have a disability and the accommodation alleviates the disability, and that you're not seeking too much information and trying to verify it and verify this. So the second reasonable accommodation or modification that you might come across is a homeowner who wants to smoke medical marijuana. So here we have Smoking Sam, who has cancer. He has a prescription for medical marijuana. He has a medical marijuana card, and he takes bong hits every night, and neighbors complain that the smoke is traveling through his unit or through the ventilation system into their units. And so here the question is, you know, what can the association do when we have a homeowner or co-owner who has a medical marijuana card and is smoking medical marijuana, and the attached condominium is what it sounds like here. So anyone wants to, I'll give a few seconds if anyone wants to step up and give us their thoughts on what the association can do here. All right, no takers. So here we have, we have a doubly interesting situation where now in Michigan, recreational marijuana has been legalized, at least across the state, not necessarily in every part of the state. But the bottom line here is that while medical and recreational marijuana has been legalized on the state level, it is still illegal on the federal level, still classified as a Scheduled I controlled substance. And in at least 2 cases, one of which was out of the Eastern District of Michigan out of 2014, and a landlord-tenant issue, so not necessarily a condominium or homeowners association, but in a landlord-tenant issue, the Eastern District of Michigan said, hey, this is still illegal under federal law. And so this at least in this instance, this landlord's not required to accommodate a tenant to engage in marijuana use that's still illegal, at least federally. And so because this is still illegal on the federal level, and the Fair Housing Act does not, necessarily permit you to grant a reasonable accommodation to break federal law, the association, does not have to grant him a reasonable accommodation to smoke his medical marijuana in his unit. And so just that distinction between federal and state level, especially here in Michigan, where now both are legalized, at least on the state level, the condominium association does not have to permit a use that's still federally illegal. And so the other hot topic under reasonable accommodations and modifications that actually there are some updates to this year out of HUD are emotional support animals. So this is again another area that if you are going to encounter the Fair Housing Act, this is likely where you're going to encounter it and likely to encounter it the most. And so here we have Sad Stan, who moves into Peeved About Animals Association. The bylaws do not allow pets. He suffers from PTSD. His doctor writes a letter to the association and recommends that they allow him to keep 3 poisonous spiders because it makes him feel better. And the association tells him, hey, these spiders are dangerous and not allowed in here. And so he files a fair housing complaint alleging disability discrimination. And so the question here is, will Stan get to keep his emotional support spiders? I would say, I used to be a teacher, so I would say I would just call in someone, but that seems unfair, especially since I can't see your guys' faces. But if anyone wants to take a stab at this and let us know if he's going to get to keep his emotional support spiders. All right, quiet group tonight. That's fine. So HUD issued guidance on January 28th, 2020 that was actually it was new, very clarifying guidance on emotional support animals and the questions that can be asked and the requirements that a requesting homeowner has to satisfy in order to qualify as being able to have an emotional support animal. And so this guidance is online. If you search, it's a document. So if you do HUD, I think, guidance on emotional support animals, it's a PDF and provides you a step-by-step analysis that's really helpful in looking at a request that you might receive and determining whether or not the homeowner has made a proper request. But just to go through the fact scenario that we have here, the first thing that you need to look at is, did this person request a reasonable accommodation? i.e., did they request to get to keep their animals because of a disability? And this request does not have to be written, which is important. So just because if a homeowner verbally asks you, that doesn't mean that they haven't satisfied the elements. So here, Stan did request a reasonable accommodation in connection with a disability with his PTSD. And so he satisfied the first standard under HUD's new guidance. The second is, does the person have an observable disability, or do they have information giving them reason to believe he has a disability? So here we have a doctor who has said, hey, he has PTSD. And so Stan has satisfied now the second level of verification that we need. So one thing that HUD included in this guidance that's important, and that I'll address a little bit later, because in addition to this new guidance, there was also a published case out of the Court of Appeals just a few days ago addressing these emotional support animals and letters that you might receive from medical professionals. And so one thing that has become common is people can just go online and basically buy a letter from a provider to say, I have this disability, I have this animal as an emotional support animal, end of story. Very vague, very general letters. HUD in their new guidance issued or stated that documentation from the internet on its own is not sufficient unless that person can indicate they have personal knowledge of the individual. So that was really designed to get at these individuals who could just go online and basically buy these emotional support animal letters, and the person, literally is just like, well, this is my name, this is the animal, but there was no investigation into what is the disability, why is this animal necessary, no personal knowledge of the person requesting the information. So that is really helpful in at least dealing with what sometimes seems like frivolous requests for emotional support animals. But here we don't seem to have anything indicating it's from an internet doctor or a provider that doesn't otherwise know Stan and his condition. So we're going to say he still satisfies that. And so the next level is, have they provided information that the animal does work or provides assistance, provides some sort of emotional support in connection with the disability. So here, the doctor just says, it makes him feel better. He has PTSD, it makes him feel better. So it's not a lot of information, but arguably it's just to say, this is emotional, it provides some emotional support. So whether or not that would actually qualify, we can leave it up to debate, but we'll just say for now, he satisfies that level. Because the next level of questioning is the animal commonly kept in households? And if it's not, then you don't need to provide the accommodation unless the requesting person can satisfy that the need for that specific type of animal or that specific animal is needed. So here, poisonous spiders are likely not an animal commonly kept in households. In fact, many people don't want them in their households. And so this accommodation would not need to be provided, and Stan would need to evidence to the association why he needs poisonous spiders, how poisonous spiders alleviate his disability, and how, for example, non-poisonous spiders couldn't do the same work, or any other animal that wasn't dangerous couldn't provide him with the same support. And so, at least, if not earlier, on the basis of whether they had provided enough information as to the support that the spiders would provide, definitely regarding the fact that this is not an animal that's commonly kept in households, unless he can show that it's only these poisonous spiders and nothing else that can alleviate my disability, this request is probably not going to need to be accommodated by the association. And so, as I mentioned earlier, so on September 17th, 2020, the Michigan Court of Appeals issued a published opinion, which means it's binding on at least the trial courts throughout Michigan regarding, in some aspects, emotional support animals. This was in a landlord-tenant context, not a community association context, but it does show at least the court's wariness of handling these requests. And I'll read to you some of the court's language just so you can see the skepticism that it appears that the Michigan Court of Appeals is inviting trial courts to have when they're reviewing whether a request is actually necessary. And so they start with, in recent years, governments have allowed citizens with certain psychological disabilities to register emotional support animals to help them navigate the world. And the fuzzy edges of these laws have spawned abuse. We have all heard the tales. A woman claiming a disability who tried to bring an emotional support peacock in the main cabin on a flight, or the United States Department of Transportation requiring airlines to permit emotional support mini horses on passenger airlines. Landlords have also felt the fallout from emotional support animal abuses, with tenants purchasing ESA certification online to dodge pet prohibitions in their leases. And so what the Michigan Court of Appeals was looking at here was a letter that had been provided by the tenant saying that one of these doctor letters saying, I have this disability and I need this animal because it provides me with emotional support. And the Michigan Court of Appeals remanded this back down to the trial court and asked them to take a closer look at the circumstances regarding this accommodation, because basically they said this was a form letter. It doesn't appear like the website says that a doctor in your network can prescribe you a certification with only one phone call, and that it would be immediately available via email for print and use. And so basically saying this was a form letter, it didn't indicate what the disability was, why the accommodation was needed. It just didn't go into any detail. And so we see at least here some direction from the Court of Appeals indicating a willingness and a push to the trial courts to be a little bit more skeptical on these requests. All right, so before we go to familial discrimination, I'll just pause for a few seconds if anyone has any questions regarding disability discrimination. So that would be reasonable accommodations, modifications, medical marijuana, and emotional support animals. All right, so we're going to move briefly into familial discrimination here. And the primary area that we see familial discrimination pop up, or areas where associations might be moving into familial discrimination territory, are swimming pool rules. But to start, familial discrimination is also defined by the Fair Housing Act. And so here it means just one or more individuals who live with either a parent or someone having legal custody, or the designee of a parent or other person having custody. And this also applies to anyone who is pregnant or is in the process of securing legal custody of an individual who is not yet 18. So again, similar to disability discrimination, a pretty broad definition. And so here we have, again, what we frequently encounter regarding familial discrimination are swimming pool rules. So here we have the Board of Cautious Condominium Association. They want to create a safe and clean pool environment. So they adopt rules that require any children under 3 to use the kiddie pool, and any child under the age of 13 to be accompanied by an adult when using the large pool that is 10 feet deep. And picky parent complains that this rule discriminates against families. And so the question here is, does this rule violate the Fair Housing Act? And specifically, is this familial discrimination? So, unless someone would like to pop in and answer, so this is an area of the Fair Housing Act that is a little bit murky. There are cases on both sides. of this issue, but a lot of the case law basically on these issues states that these rules that target families, and specifically children, do violate the Fair Housing Act and are familial discrimination. And so there's a number of cases out of California with similar rules where they found these rules to be familial discrimination. So specifically, rules that said children under the age of 18 are not allowed in the pool or pool area at any time unless accompanied by their parents was found to be discriminatory because it treated families and specifically children and their families less favorably than just households where there are only adults. Similarly, out of California, rules that created, so what we have here, a kiddie pool, so rules that created a family pool, an adult area, and prohibited children from playing in or around the adult areas. Those were discriminatory based on familial status. And even in instances, so the trouble with these rules and that what some associations have are, you know, we're really doing this to like protect the children. Like we're trying to do this for the children's benefit, especially regarding a swimming pool. You know, we want to keep the pool water safe and clean, but we also want to keep children safe when they're around, especially these deep swimming pools. But the courts, while they're sympathetic to that, at least a number of them still find that targeting and selecting children and families with children versus just adult-only households treat them differently in our familial discrimination. And so some of the updates, so earlier I mentioned a case that recently came out of the federal court in Idaho regarding similar familial discrimination claims. And so this association was found to have its rules violated the Fair Housing Act on the basis of familial discrimination based on rules that said that adults had tennis court privileges over children. Clubhouse was for adult use only during the summer months. And also that residents 14 to 18 could only have one guest, while adults, so anyone 18 and over, could have unlimited guests. And so again, the courts are really looking at the underlying basis is for behavior or conduct that also could be committed by adults. So many times it's also to, you know, we don't want noisy children causing a ruckus, but an adult could be just as noisy and cause a ruckus as well. Some of them are also based on, you know, we want to make sure, you know, that the children don't drown. You know, they may not be good swimmers. We want to make sure they don't drown in the pool. But you could have adults who also don't know how to swim very well either, and may also face a risk of drowning, but we just don't have rules that regulate that. And so the courts are really going to look skeptically at what is the underlying basis of the conduct that you're trying to get at, and could that just as easily be committed by the adults as it could children? And is this, at the end of the day, really just unfairly targeting families, even if not specifically, but that impact question of, is this unfairly impacting families? And so one interesting wrinkle here is for, there are some communities that are housing for older persons, so they're 55 plus communities. And so HUD has said, you know, that these facilities are exempt from these claims of discrimination on the basis of familial status because they already restrict, you know, families with children from being in the community. However, we do recommend many times these communities do allow their members to have guests, which could include children. And so because those children would still be coming into the community, to still make sure that those rules aren't right for potential familial status discrimination claim based on the fact that even though your members may not be children or have families with children, children are still coming into your premises. And so just to make sure that your rules still don't unfairly target them. So that's, the main instance of familial discrimination. And really, even just to go back, this applies, as the District of Idaho case points out, we see these roles in fitness centers and gyms where, the child is maybe supposed to be supervised, or maybe it's not allowed in the fitness center for various reasons. And so really this could apply to any of the associations, common areas, especially recreational facilities, not just the swimming pool, but that's where we see a lot of potential familial discrimination issues kind of lurking in the background. And so next we're going to talk about race discrimination. And so what the association's potential liability and responsibility is for race discrimination that might be occurring among their homeowners. So here we have a homeowner who the association does not have any bylaws regarding flags or signs. So the association's not going to be able to say, hey, you're not supposed to post or to have this flag or post this sign. But he puts out a sign that says, we want white condominium owners. And then apparently also too, on multiple occasions, he's cornered minority condominium owners in the parking garage and told them that they are not welcome. So here we have an instance of a homeowner who is engaging in race discrimination with other homeowners. And a question of what is the association's responsibility in these instances. So not as recent as some of the stuff that we've gotten in 2020, but in 2016, HUD did issue guidance on what's called a hostile environment harassment claim, which is something that might be applicable to this situation here, which basically involves a showing that there's unwelcome conduct that's sufficiently severe or pervasive to interfere with a person's ability to use or enjoy their dwelling or the services or facilities in connection with their dwelling. And so it's important to some of the clarifications under the HUD guidance that if a homeowner, so for example here, if any of these condominium owners brought a race discrimination claim under the FHA, they don't need to evidence that there was psychological or physical harm to prove that a hostile environment exists. And so, even though Randy hasn't taken any physical action against them, his cornering them could be potentially enough. Also, the HUD guidance clarifies that it can be just a single incident of harassment can be enough to qualify as hostile environment. And so depending on the severity of the conduct and how frequently it occurs, this could end up being a potential hostile environment claim brought by these minority condominium owners. And so regarding the association's responsibility, HUD also clarified who can be held potentially liable under a hostile environment claim. And so first, of course, is the person's own conduct. So here, Randy is committing this conduct by himself. He could be held potentially liable if a hostile environment claim exists. The second level of liability is someone who fails to take prompt action to correct an discriminatory housing practice by that person's employee or agent, where the person knew or should have known of the discriminatory conduct. So here, this could be, for example, a property management company who maybe, let's say, Randy is instead a community manager for some reason. And so if the property management company becomes aware that one of its property managers is committing this conduct, they would need to make sure that they are taking prompt corrective action to try to end this discriminatory behavior. And then the third level of potential liability is someone who fails to take prompt action to correct and end a discriminatory housing practice by a third party, where the person knew or should have known of the discriminatory conduct and had the power to correct it. And so here, this is where the associations could potentially come in if the association knew or should have known that this was going on. And so if there's some basis under the bylaws or the rules and regulations to regulate, many times in our condominiums, we have provisions regarding nuisance or offensive behavior. If there's some basis under which the association can address the conduct, and put them on notice that it's not appropriate behavior, the association will want to do that because HUD does establish that if you do have the power to do something and you know about it and you should have known about what was going on and you didn't do something about it, there could be potential liability there. And so regarding the second question about Randy's First Amendment rights, HUD does make a statement saying, when they receive and review these hostile environment claims, they do consider First Amendment rights. And so they are going to take a look carefully and make sure that they're not going to chill anybody's First Amendment rights. But when the statements start transforming from statements to what seems to be threatening or statements of threats, that's when the balance is going to shift against protecting that homeowner's First Amendment rights. And so, for example, some instances where the conduct was just related to speech, similar to Randy's here, violations were still found. For example, when a homeowner just made racial slurs within earshot of the complainants, when a woman told another homeowner that he couldn't live on her block and just pointed at him saying that there would be trouble if he moved next door. And so even just statements, again, could potentially be enough. And if the association becomes aware of it, you'll just want to act quickly, especially if you have a basis to under your governing documents. All right, so finally we have here, or not finally actually, fourth, we have religious discrimination. And so one thing to note is that the Fair Housing Act does not require accommodations based on religion. So you may have to grant a reasonable accommodation or modification based on someone's disability, but you're not required to do the same based on somebody's religion. So we'll just start off first with this set of facts of Aesthetic Acres Condominium Association has condominium bylaw that prevents balcony storage. Ronald Religion puts a John D or a flag and a pot of dead flowers on his balcony, and he claims that he has to fly the flag based upon his Hindu religion. And so the association fines him for violating bylaws by storing something on his balcony, and he sues the association for religious discrimination. And so the question here is, who's going to win? And I've already gave away the answer a little bit earlier, but here the association's going to win. And it should be important to note that the basis for this is the consistent enforcement of these bylaws against all co-owners within this association. And we'll see how that gets flipped on its head in the next set of facts. But here, so this was a case out of the Fourth Circuit in 1994, and the court had found that this co-owner actually he didn't have to store this pot of dead flowers on his balcony to be, consistent with his religion. In fact, there were other Hindus in the community who did have John Dees that weren't stored on their balcony and could do so in compliance or, consistent with their religion. And two, he did not submit any evidence that the association had permitted other tenants to place any other items, whether religious or not, on their balconies. So they were really consistent in enforcing the balcony storage bylaw consistently against everyone. And so because of that, the court found that there wasn't a basis here to find religious discrimination on the part of the association. And so here the association, because of its consistent enforcement of its bylaws, would win. And so, as I mentioned, and again, unfortunately, gave this away a little bit earlier, here we have it on the flip side where same association, they have a hallway rule that prohibits mats, boots, shoes, carts, objects of any sort from being stored outside a unit entrance door. Ronald converts to Judaism. He hangs a mezuzah outside his hallway door. An example of one of those is pictured here on the slide if you're not familiar with one of those. And the association, they allow other owners to have coat racks and tables out in the hallway. And the board president takes the mezuzah down and tells Ronald if he doesn't like it, he can get out. And so Ronald Religion here sues for religious discrimination. And so the question is who would win? And so here we have an issue with an association who is not consistently enforcing its bylaws and appears to be selectively enforcing it against Ronald based on his religion. So this was, again, a case out of the 7th Circuit in 2009. There was also other evidence too, part of the record that showed that this association did not have a good relationship with this set of owners, particularly regarding their religion, and to the fact that they were allowing storage of coat racks, all these other items out in the hallway. They were not consistently enforcing this, and when they decided to, they only enforced it against Ronald and his mezuzah. It was found to create an inference of discriminatory intent as religious discrimination under the Fair Housing Act. And so, again, the emphasis on religious discrimination claims, and really all of the condominiums documents, or if you're a homeowners association, all of your governing documents, is really making sure that you're consistently enforcing whatever rules that you have in place to help eliminate potential arguments of selective enforcement under one of these bases of discrimination. And so if anyone has a question, I'm going to pause before I go to the last section, which is sex discrimination, which also has some recent updates. And then I also need to move my computer to charge it up. So I will give a few seconds if anyone has some questions while I'm transferring my computer. All right, so seeing no questions, we're just going to go ahead and move into the last section here, which is sex discrimination. And so here we're just going to dive right into a hypo, which is Deviant Danny, who serves on the board of Oblivious Acres Condominium Association. Co-owner Cindy has a roof leak and advises Danny that it needs to be fixed. And Danny tells Cindy that he would have the board fix the leak if she goes on a date with him. And Cindy complains to the board, and the board takes no action. And so the question here is, has Danny or the board violated the Fair Housing Act? And I feel like this question is so easy. Someone's got to speak up and let us know if Danny or the board violated the Fair Housing Act and why. Any takers? It's like a gimme question. So here we have both Pete and the board violating the Fair Housing Act, or sorry, not Pete, Danny. So Danny clearly has violated the Fair Housing Act. This is part of HUD's earlier guidance on hostile environment harassment. So they listed, you have hostile environment harassment, which is unwelcome conduct that doesn't necessarily require an exchange of anything between the two, and it's just severe and pervasive unwelcome conduct. But they also talked about quid pro quo harassment, which is an unwelcome request or demand to engage in conduct where submission to the request or demand is made a condition related to housing related services. So here we have Danny specifically telling Cindy, hey, we'll fix this roof if you go on a date with me. And so Danny has violated the Fair Housing Act and has a housing sex discrimination claim based on quid pro quo harassment. And then similar to the hostile environment claim where we listed the different levels of potential liability, the board has also violated the Fair Housing Act because they knew of the conduct. Cindy put them on notice, said, hey, your board member, Danny, told me that I'm going to have to go on a date with him in order to have my roof leak fixed. And instead of taking corrective action against Danny for this quid pro quo harassment, the board didn't do anything. And so because they knew of the conduct and they could have responded and taken action against Danny regarding this improper behavior, and they didn't, they would also be potentially liable under the Fair Housing Act as well, or promoting quid pro quo harassment. And so last but not least, another area of the law for Fair Housing Act claims that is quickly changing is coming out of this final scenario that we have here, which is we have a homeowner who was born a female, now identifies himself as a male, and the condominium or the property owners association in response adopts a rule that prohibits women from using the men's bathroom in the clubhouse. And Terry requests the association to provide him an accommodation to use the men's bathroom based on his status as a transgender person. And so the question here is, should the association grant him an accommodation? And so if you happen to pay attention to the news this summer, you may be familiar with the case Bostock versus Clayton County that came out of the Supreme Court, which held that sex discrimination under Title VII or employment law includes a person's sexual orientation and their transgender status. And so, you know, a person couldn't necessarily, and we'll see down the line potentially some caveats, but generally a person cannot be fired based on the fact of their sexual orientation or the fact that they're transgender. And so while that case on its face looks like it's really relegated to employment law and Title VII, federal and state courts, when they're interpreting the Fair Housing Act and what qualifies as sex discrimination under the Fair Housing Act, they look to employment law. And so this case is new. And so, you know, I haven't seen anything yet come down regarding, you know, a housing sex discrimination claim based on sexual orientation, transgender status after this case. There were cases before it. But you should anticipate that housing sex discrimination claims now can also include discrimination based on a person's sexual orientation or their transgender status. And so it's really important to make sure that you're mindful of that moving forward, or if you get a similar request to this. And one thing that has come out since this opinion, so this opinion just came out, I believe in June or July of 2020. So again, it's still pretty new, but the Fourth Circuit issued a published opinion in August 26th, so just about a month ago, out of Virginia, I believe it was, that a school board's policy requiring students to use bathrooms based on their biological sex was unlawful discrimination under Title IX. And so again, Title IX is looking at Title VII employment law to determine what encompasses sex discrimination. And in this case, they looked at this Bostock opinion and said, okay, Title VII sex discrimination includes a person's sexual orientation and transgender status. And so under Title IX, this is also unlawful discrimination. And so as we move forward, we can definitely expect to see in the housing world that when courts are receiving fair housing claims that are arising under housing sex discrimination, that transgender status and a person's sexual orientation is going to be included as part of sex discrimination claims. And so as a final wrap up here, just some overall recommendations. As I mentioned earlier, reviewing your governing documents and any rules just to flag potential areas of violations of the Fair Housing Act. Again, recreational facilities are areas where many times we see they may not necessarily be violations, but we recommend some changes really just to make sure that we're not wading into that territory, and really making sure that as a board, you're consistently enforcing your documents and your rules against all your homeowners. As we saw, that was very important in one of our cases out of the Seventh Circuit, and the fact that it wasn't being consistently enforced against all the homeowners. Also, too, to adopt a reasonable accommodation and modification policy. This is helpful both for the board and reviewing these requests, so you kind of have a step-by-step guide of, okay, what can we look for, what can we request, but also when your homeowner is submitting a request, that from the beginning they can look at, this is what the board's going to want to see, and really trying to move those conversations along as quickly and amicably as possible to get them resolved in whatever way they need to. And to also too, if you receive a complaint, whether it's from HUD or the Michigan Department of Civil Rights Commission, that you consult with an attorney and get some guidance on how to move forward, and some representation in that regard. And also too, we offer here as well, as I mentioned, reviewing your rules to kind of point out some areas of where there might be some potential fair housing violations. We also can help to and advise on proper accommodation modification requests, and if the board is agreeable to a request, drafting agreements that also comply with the Fair Housing Act as well. And so these are really just areas that they pop up a little bit more than you might think, and so we're always here to help advise you along the way. So I will open the floor one more time for any rounds of questions that you may have.
I have a question. Can you hear me?
Very low.
Okay, let me try it again.
Oh, I can hear you.
Can you hear me now? Okay. So we have a condo association with independent single site condominiums, 60, and it's a water issue with children. We do not have an enclosed formal swimming pool. We have open water and docks. How do we deal with the idea you brought up of the idea they knew or should have known with parental responsibilities? Should the parent not know that young Sally, a minor, may be at risk if she, the parent, allows her to go down to the dock unattended and a tragedy happens? Should not the parent have knew or should have known the degree of risk allowing her minor child to be at the water unattended?
So at least regarding the association, the new or should have known, that level, that 3-tiered level of liability is specific to hostile environment harassment and quid pro quo harassment claims. Yes, I recognize in general, and again too, this is something I mentioned earlier, this is definitely a sticky point for many associations, as we see not just here in Michigan, but across the country, of associations weighing these balances of, we have these recreational facilities, we have open water areas. We want to make sure, that children who, may not always be aware or able to weigh all these risks themselves, can provide them, or we can establish some sort of rules to try to, protect ourselves and make sure that these kids are being, monitored or supervised in any manner, and really trying to shift that burden over to their parents or legal guardians. But the courts are just a little hesitant. I shouldn't say hesitant, but the courts really weighing the balance are just seeing the underlying conduct is also applies to both children and adults. So for example, an open water concept, might be dangerous for a child, but it could also be dangerous for, maybe an intoxicated adult or an adult who doesn't know how to swim. And so when they're weighing that type of stuff, they're saying, okay, adults are just as capable of this conduct as well, or adults may require the same supervision, or may face similar risk. And so when they're weighing those things, and they're noticing that they're really just affecting families of children as opposed to people who are just in adult-only households, at least more, I would say more than not, they've been willing to say that there are familial discrimination claims.
One more thought. Thank you for your time. We are having a situation where parental rights is being pushed back against the association with the Fair Housing Act theme. Where is the line where the association responds, where the parent says, I'm the parent, I have decided that Sally is sufficiently capable of dealing with the open water on the dock, and she's a minor?
So I'll just note here, like, this is just kind of general guidance. And just for the benefit of everyone on the call, so may not directly hit at your question. But again, the way that the courts look at this is, for example, lifeguards, one thing that, especially regarding swimming pool rules, is courts have looked at the fact that lifeguards can be certified as early as like age 15. And so they're just like, if you have, let's say, this child is a minor, so she's under 18. So let's say she's 16. And if there's rules regulating her conduct, but at the same time, the association could also technically hire a lifeguard who was 15, who wouldn't be technically prohibited, would be certified to engage in the open waters. But, this child who's a similar age, who may be a very experienced swimmer versus a 40-year-old adult who has no experience swimming whatsoever, that's the type of analysis that the courts are going to look at. And so it's not even necessarily minority, parental rights. It's really getting at the underlying conduct that is being regulated, and kind of the rationale behind the rule, and whether or not would this apply equally to adults, and are we regulating adults in a similar fashion?
Fair point. Thank you.
Anybody else? All right, well, I'm going to stop the recording now.